Well, I'm going through a divorce,
Okay.
and I've been married to my husband now for about, it'll be 23 years, March the 20th. And this will be our third time going to court, but they're telling me that I may not be able to get spousal support because he don't make enough money.
So how is that judged on, who gets the spousal support, or if, in her case, if she can get it?
It's a great question.
I don't know what's in the water, but I've had this issue to come up at least 3 times last week in consultation with clients. There are various factors that the court look at in determining whether or not to grant or deny alimony. Some of those factors include the health of the parties, the age of the parties, the misconduct of the parties, and even when you have those elements, one of the most important factors is the ability to pay. I've had some clients to consult with me where they in fact made more money than the person, but they felt like they were entitled to alimony, maybe perhaps because of the length of the marriage, because of maybe that person committed adultery. But if they don't have the ability to pay, then there's no alimony. I'm sorry. Alimony is not designed to punish a person. It is designed to maintain what we call the status quo of the parties. So other things that the court look at is like the standard of living that the parties have lived throughout the marriage. They look at your future prospects, your ability to maintain that standard of living. So just depending on each and every individual situation, it would determine whether or not there should be a grant or denial of alimony. And I should say this, that just because you've been married for 30 years does not necessarily mean that you have an alimony case. And just because you've been married for 3 years does not mean that you will not get alimony. The court will look at all of those factors, the income, misconduct of the parties, standard of living, health, welfare, in making those determinations.
Kitty, what about retirement plans? Do they come into that equation at all?
Well, retirement plans, one requirement is that the retirement must have accumulated for at least 10 years throughout the marriage. So, for an example, if you met the person and they were already retired, and you stayed, then you married them, and you were married for 20, 30 years, that is not accumulating through the marriage. That's retirement is already in place, and no, you're not entitled to that. Also, I have people where the person may have worked a job for a number of years, and they got married and they stayed on the job. Remember, the key is, has the retirement itself been accumulating throughout for at least 10 years throughout the marriage? And even if not, that just means that you don't get a fair share of, or whatever share of the retirement itself. But it does not mean that the court cannot consider that amount in determining alimony payments or property settlements, because that still, at the very least, is considered part of their property settlement estate. So the court would say, okay, well, I can't give you half of his $100,000 retirement, but I'm not going to ignore the fact when I'm deciding this equity division in the house that he has $100,000 in retirement over here. So it may be that you can't get half, but the court can still consider it to be part of his separate estate.
Great information.
All right, yeah.